And before we proceed, I'd just like to get the attorneys to make their announcements and introduce whoever you have in the virtual courtroom.
Jason Wright for Petitioner Bismarck Boki, Katie Valle as well for Bismarck Boki. We also have Auburn Gallagher and Tanya Pogue, who are the exchange supervisors for the case.
Okay.
Good afternoon. Good afternoon, Your Honor. V. Wynn for Lavisha Stingley, the mother, the respondent in the matter.
Okay. All right. Thank you. And who is Mr. or Ms. Kerr?
That's my sister. She's a witness.
Okay. Well, this is not an evidentiary hearing, so I'd be surprised if we are hearing from any witnesses. Typically, these hearings are very short, and so we do not take testimony typically. Mr. Wright, it's your motion, so you may lay out your arguments.
Thank you, Your Honor. Yes, as our petition states, Your Honor, we have a situation where Ms. Stingley has once again taken possession of, at this time, one of the children outside of the court order. She has taken the child and is now hiding the child from my client. She has taken the child from the school. There was an incident, as our affidavit and our pleadings state, where she attempted to take both children. My client was able to take possession of his son. She drove off with the daughter, and that was on the 1st of March, and the child has not been returned to school since. We have not, and we don't know where the child is, and has not been returned. He has possession of his son, but on Monday or Tuesday of this week, there was another attempt to take possession of him by the mother, this time using a male friend of hers to approach the child. They were able to avoid that. Police were called. An incident report was made, but the mother drove off. And so since that point, my client has kept his son away from school to avoid potential risk or being taken, since the school doesn't have any orders to prevent people from going up there, or there's an issue there. So that's where we are. That's where we have pled for what we've pled for. This will be, or would be, the third time that we've had to get the court to order Ms. Stingley to return the child. We felt like a writ of attachment at this point was more appropriate than a writ of habeas. We've had 2 writs of habeas issued against Ms. Stingley in prior times, and at this point, we don't know where she is. We don't know where the daughter is. We need the court's help, and we need some new orders in place to get some temporary orders. But what we really need is some emergency relief to get walls in between, multiple walls in between Ms. Stingley and her children for any kind of possession between now and when we can get this case resolved. So that's why we're here, based on our pleadings and the affidavits attached to it. The supervisors are here. If the court has any questions or clarifications as to why or how we got here, I can clarify that as well. But that's why we've pled what we pled.
Okay, understood. And I did review the application and the papers that you have filed. Ms. Wynn, I am interested in hearing what your client has to say for herself.
Understood, Your Honor. Good afternoon, Your Honor. I guess I can say it this way, Your Honor. First of all, I'd like to say that we definitely need some emergency orders with you, Judge. I think the last time I was in front of Judge Rodriguez, it was a long, very long hearing, supervisors involved. Where things got to this point, Judge, is because the supervisors have made a CPS report, and then they wrote an email saying they were no longer be supervisors, and then everything just stood still. And then you had dad holding on to the kids, not exchanging the kids, and here we are, Judge. So what we would like, Your Honor, I can't defend what my client is doing one way or another, but I do believe that we need some orders for you, especially in light of the fact that supervisors are not wanting to come forward and do the exchange. And as a result of that, Judge, we got 2 people. It's like a showdown in a sense, or a standoff in a sense, that nobody's exchanging children because the supervisors don't want to be involved. And CPS has closed their case against my client. So, Your Honor, in all, we are asking for your help as well. I know that it had to kind of lead to this emergency hearing, but we need some orders, Judge. Guaranteed. That's what we need. And I wasn't a part of of what happened with this whole thing with school or anything like that happened when I was apprised of it. I know that Mr. Wright had asked me about it, and I said, well, we definitely need some orders in place. And when this hearing was set with you, I thought this would be a great opportunity to have you admonish or tell everyone that what we need to do, because otherwise we have no orders.
Okay. And Ms. Nguyen, you don't dispute the allegations that Ms. Stingley is not entitled to access and possession. She took the child from school on a day and time that she did not have access and possession.
Your Honor, I would say that if it was outside the orders, then definitely I would not dispute as an officer of the court that that's the case, Judge. No.
Okay.
The only missing piece is that the orders that we have in place, that Judge Rodriguez put in place, was that supervisor would stay in exchange, but we no longer have those people involved.
Well, and
not to defend what my client did, though, Judge. I don't mean that as well. Yes, Your Honor.
Okay. Let me just, I guess, Ms. Gallagher, if you want to just give the court a very short synopsis of why you're no longer willing to supervise these exchanges. You're on mute, though, so you need to unmute. Ms. Gallagher?
Okay, got it, Your Honor. I'm sorry.
That's all right.
Okay, Your Honor, the reason I terminated my part with the exchanges is because there's been an ongoing situation with these children coming back reeking of marijuana. It's been an ongoing problem. The last hearing we had, after the hearing, Ms. Stingley tested positive 8.85 picograms of Delta 9, which is illegal in Texas. That is not medical marijuana. And currently, what finally did it for me is the last time I exchanged these children, the son, Junior, when I got him from Miss Stingley, was so high he could barely stand up. He was very lethargic, reeking of marijuana. When Mr. Boinke took him to get a hair follicle test, he tested over 40 picograms of native THC in his hair follicle. And I, Your Honor, with good conscience, cannot continue to exchange these children when I feel like they're at risk and they're unsafe. That's not something I'm willing to do.
Okay. All right. Thank you. I appreciate hearing from you. Mr. Wright, is there anything else that you have not mentioned to the court as far as the TRO or the writ of attachment?
Yeah, other than I just want to clarify, it was 4,000 picograms, not 40, that the child tested positive for. And there are no affirmative plea. As far as I know, Ms. Nguyen has not filed anything. I have not received any notifications, communications, anything from her regarding the change of exchanges, trying to get a new supervisor, filing any kind of motion. This is, again, another example of self-help by her client. And when I will say, Ms. Nguyen's responses to me earlier in the week before we filed, when I tried to reach out to her, trying to solve this without the court's intervention, was not exactly as cooperative and forthcoming as she represented today as far as her position on what her client has or hasn't done. So that's what's led us to this position. We just need to get these kids back, and I need to keep her away from that school, and we need to have no access to possession until we can have a full evidentiary hearing on this issue.
Okay. And Ms. Nguyen, your client understands that the court is being asked to send a law enforcement officer to retrieve the child.
She is aware. I think the previous writs that she's had, Judge, which I wasn't a part of, my client is aware of what the significance would be with those orders, Judge.
Okay. Have you discussed with her whether it would be a good idea to relinquish possession of the child in lieu of the court sending law enforcement to pick up the child?
No, Your Honor, I haven't. But I can definitely do that. If you give me a moment, I could definitely do that for us, Judge, if you would allow me to. I would tell her.
Okay. Well, the time to do that was probably before this hearing started, in all honesty.
Understood, Your Honor.
All right.
Your Honor, but
Ms.
for the
Dingley
sake of time,
has her hand up. Ms. Nguyen, this is not an evidentiary hearing, so typically we don't hear from a bunch of witnesses because these are short hearings. But I'm going to go ahead and unmute Ms. Stingley, or ask that she unmute.
Hi, Your Honor.
What is it that you want to tell me?
Well, yesterday, actually, I went to get my kids when it was my possession. I did not go get them when it wasn't my possession. The Friday I went to retrieve my kids, it was my possession to have my kids. And also, yesterday, I went down there to return the kids, and I sent him a message that I was there, and he didn't show up. So I tried multiple times to return her, and he never showed up. You can look in the app, Close app, and you can see all my dates, all my timestamp, everything. And Your Honor, he's been keeping my kids away from me since November. I have not seen my kids since November. He'll show up to the change place and he will take off. And I have pictures and evidence of everything. He will show up, he won't give me my kids, he'll take off with them. So it's stuff he's been doing to me. And it's not just, I just went up there and took my kids. I went up there on the day I was supposed to have them because I knew he wasn't going to change them with me. And I got them on the day that I was court ordered to get them on, Your Honor. It wasn't like a day that wasn't mine.
You got one kid, but not the
Yes,
other?
I had both of them in my possession, but the father aggressively pushed me in the
Your Honor, I'm
kids.
going to object to if we're going to have a testimony.
And he grabbed the son
I'm
from
gonna
me.
get into
That's
this.
why.
I mean,
All right.
Yeah.
That's it, Ms.
And I do want to
Stingley.
offer,
I don't
Your
need
Honor,
to hear anything more.
Your Honor, I want to point out that the current further temporary orders that were issued in this case, based on a hearing in September, they're filed in this case, show that I do not see that she has a possession on a Tuesday or a Monday, which she was attempting to take possession of her son this week. She also does not have, it is ordered that she does not have any Thursday evening possession, but she has weekend possession. So while she might have been trying to take possession, I don't know if the weekend fell on a weekend or not, she does not have possession to go to the school and take possession of the children. The orders do not allow her to do that.
I understand, and I read the further temporary orders before this hearing. So Ms. Nguyen, it's apparent to me that your client either doesn't understand or doesn't care what the orders that are in place say. And so you need to have a serious discussion with her offline about the consequences of what can happen when she repeatedly refuses to follow court orders.
I
And
understand,
yes,
Your Honor.
I do mean serious consequences such as jail, paying the other side's attorney's fees, and court fines, all of which I think will be on the future table at the next hearing. But for today's purposes,
And I know, Your Honor, that you...
Go ahead. Go ahead.
No, you're right. And I know, Judge, that we're only before you on a writ, and I know there's no opportunity to have any kind of emergency relief that would help us at least alleviate the supervisor issue. I think if we had that, given that Ms. Gallagher, of course, you know, as giving her reasoning, but because we don't have a supervisor, then if there's any way, Judge, if you could help us, and at least in that respect, and during the interim, if we could just have a new supervisor or new arrangements in place, Judge. And then that way we can get back before, you know, our next docket, whichever judge will be in front of, Judge. But in the meanwhile, my client hasn't seen the kiddos since November, and even before that, she hadn't seen them for months. And it's this whole issue over the supervisors.
Okay,
and
you'll
so
get
that's the main thing.
There's going to be a full-blown evidentiary hearing in a couple of weeks. Okay, that's your chance. But this is a short evidentiary hearing where what is brought before the court is that one of the children was exposed to excessive amounts of illegal substances under her care. I'm not going to give her any temporary possession in between now and that next hearing. That's a risk I'm not willing to take, especially given the repeated violations of court orders and the absconding with the child while not on her time of access and possession. And given the fact that this has happened before, not just once, but 2 habeas petitions. So your client, you need to have a serious conversation with her. Okay.
Understood, Your Honor.
That's all I can say. I do not like to issue writs of attachment. I do not like to involve law enforcement officers in what should not be required. But when people cannot behave properly, and when people repeatedly fail to follow court orders, sometimes it's necessary. Your client has made it necessary for the court to enter this writ. So I'll grant the TRO. I will sign the writ of attachment.
Your Honor, can I ask, we do not have a current address for Ms. Stingley.
Yes, Miss Wynn, I need that, and I need it now on the record. Well, there's no record, but I need it now.
Yes, Your Honor. I only have what I would have had in my file, but I guess she would have to be able to provide any new addresses if that's changed, but she's not told me their address has changed.
Okay, Miss Stingley, we need your address. You can unmute.
It's the address I always had. He done sent the police over here, so he knows where I stay.
I need the address.
It's 66.
And the child is with you at the residence
She's
today.
with me right now. You want to speak to her? She's up there
No.
playing with the kids.
No, I don't need to speak with her. I just need to confirm she's there. Thank you. Miss Wright, or Mr. Wright, did you get that address?
I did, and it was a little fast. 6609. Obviously, Your Honor, I appreciate it. If you're executing the writ and there's things between now and then, obviously, if Ms. Stingley can return the child within the next hour and a half, that can avoid the issue of police officers coming to her residence. But obviously, being it's Friday, we're going to need that writ issued, and we're going to have to move forward with that. But we would love to avoid exposing the children to the police doing this.
Okay, Miss Stingley, what is it?
Well, it's actually my position to have my kids right now. So I can't use my position of my kids right now because they on spring break and it's my position.
Hello. How's it going?
I don't know which school district the children are in, Mr. Wright, or whether that statement.
I don't know. I mean, Your Honor, our position is.
They got out of school yesterday for spring break, and I suppose I got them yesterday on spring break. That's what the court order said. And I was there at 6:30, and he did not show up, and I had the daughter with me at the exchange spot.
Your Honor, if I might, Ms. Stingley has taken possession of these children and has kept the daughter out of school to reward her for these are all evidentiary
My
matters.
daughter has a doctor's note for school, so she can take back to school. It's not I kept her out of school. She has a doctor's note.
Your Honor, I don't want to talk over her, obviously, but we certainly do not agree to the child being exposed to her and her environment any longer than she already has. It doesn't sound like she agrees to bring her over. So if you need to issue the writ and the police need to go get the child, that's fine. I was simply trying to offer an opportunity to not expose the children to the police intervention, but we certainly do not agree to the idea of allowing the child to stay with her any longer than she already has and what she's been exposed to. We can, I'm pulling up the address right now if we need to figure out where she's at, but
all right.
We certainly don't agree. She wants the benefit of whatever the order says when she likes it, but then she wants to violate it however she
I don't want
wants.
to follow the order either because he kept my kids from me. So it's okay if he do it, but it's a problem when I do it. I'm in court now because he kept my kids. If I would have never took my kids, we wouldn't be in court right now. He would still be keeping them.
That's a true statement. That's a true statement.
Yes.
If she had not taken the children when she did, we would not be here. That's right.
Yes.
They have not filed
anything.
anything.
To have my kids. It was my time.
Right.
It was my week.
Yep.
Okay, I need y'all to not speak over each other. Miss Wynn, let me ask you a question.
It's not fair to my kids.
Okay, Miss Wynn, do you want the opportunity to confer with Mr. Wright about whether your client will agree to turn the child over today? Or should I go ahead and sign that writ and send law enforcement to accomplish what should have already taken place?
Your Honor, any other situation, I would say give us an opportunity to confer, Judge, but given the history of this and the tension and all of that, I will just defer to what you think is best, Your Honor, because, and we're not saying best, but it is such a contentious thing. We were just there a few months ago and always something going on one way or another. But I understand,
Your Honor,
Judge,
I'm so sorry.
Your Honor, and if I could, that's why I just stayed as quiet as I could, just allowing me to speak when I could, Judge, but I understand that you're going to issue this writ. It is given my client spring break time. She hasn't seen her kids since November, Judge. I know that all of this has a lot of complexity to it, but we will do what you tell us to do, Judge.
Okay.
Your Honor, if I have one point,
Yes.
I've tried to pull up the address that she gave, and it's coming up as a Zillow house that is completely empty and for sale. So I just all I can tell you is the address that 549 comes up as an empty house on Zillow.
All right, Ms. Stingley, do you want to answer that question?
I stay at 60. Show you a piece of letter mail that I have here. That's my address, ma'am. That's
All
my
right,
address.
if you have something that shows the address,
I'm
that's
honestly telling. Yes, let me go find some.
Your Honor, I just typed it into Google.
Mr. Boyke, I think, is in the gallery, Your Honor. He definitely can confirm the address that he sent the police officers to that just recently, and that they did a welfare check.
It's my address right here. 66.
Did you get that, counsel? I did not.
It was pretty fast. I saw it comes up on Zillow.
Okay.
So,
Well,
we'll deal with whatever we have to deal with, Your Honor. I'm just.
okay.
Can I bring
obviously
my child? Because I don't want her exposed to no police. She already don't want to come back. So I definitely don't want to expose her to no police. So I will bring her.
Okay. How quickly can you deliver the child?
I can have her there by 4 o'clock.
Okay. What's the location, Mr. Wright?
They're trying to take you from me, okay?
Let's see.
Ma'am, it is against the rules for you to discuss an ongoing
I
matter.
don't want to keep my kids away from what y'all doing to them.
She needs to exit the room now.
Go. I'll talk to you later. Go.
I can have an address. Let me, if I get with my client. I'd like for her not to go to his residence, so we can.
Yes, a public library.
Yeah.
Police station, fire station.
Bismarck, what's the nearest neutral location that we can meet at?
I can meet him at Georgetown Police Station.
Okay, that's fine. Georgetown Police Department. Let's see. Looks like 3500 DB 8628. I can put that in.
Okay.
I will email that to opposing counsel.
Okay, and Ms. Stingley, you're representing to the court that you will deliver the child to
I
the
will
police
at
station
4 o'clock.
by 4 o'clock. Okay, thank you for agreeing to do that. If you fail to do so, obviously the writ will be issued. Do you understand that?
Yes, ma'am. I understand. I will do it. I have no
Okay.
problem doing
But the
it.
temporary restraining order is
So-
being entered. So, Ms. Nguyen, you need to speak with your client about all of those provisions, okay?
So I can't see my kids?
And Mr. Wright, have you obtained the hearing date for the further hearing?
I believe so. I can confer with my paralegal. I believe we put in the proposed order. I think it's the 22nd, which is 2 weeks from today.
Okay.
And I know that you instructed counsel, but I would ask the court if you wouldn't mind to instruct Ms. Stingley directly what the request that we're asking as far as staying 200 yards away from the school and the home and no access and possession until the 22nd?
Yes, those are the terms of the temporary restraining, which will be signed by the court. Ms. Nguyen, you'll get a copy of that to share and explain to your client the conditions. She'll be able to, y'all will have your day in court on the 22nd. So be prepared with evidence and witnesses at that time. I don't have anything else for you.
Just for
Disappointing to
procedurally,
meet the parties under these conditions.
we agree, Your Honor. I hope that we won't have to contact, but obviously that if we don't hear anything by 4 o'clock, we'll be reaching back out to your staff.
Yes, just email Miss Sear. The child is not delivered by 4 p.m. The writ will issue.
Okay.
The TRO will be signed regardless. Okay.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Seeing nothing else, you're excused from the virtual courtroom.